All right. Can you hear us on Zoom now? I'm just gonna wait a second. Can you hear us on Zoom now?
Yes.
Perfect. So you'll have to wear this. I'm sorry. So I was you hadn't missed anything. I was just introducing the chair and the program. I'm just flagging a couple of events that are upcoming, such as the Hyman Soloway Chair Colloquium on trade and gender, and then we have a big event coming up in early May that will also be that will also involve a public panel on the 24th. So stay tuned for more information on that. Now, without further ado, let me talk about tonight's event and tonight's speaker. So we are very privileged to have Professor Julian Arato from the University of Michigan Law School here today, talking about the institutions of exceptions in international investment and trade law. That's obviously a very important and topical issue to be discussed in international trade law. We are in a period of turmoil. Trade law is not anymore about freeing international trade, liberalizing borders. Trade is increasingly about leveraging trade policy in order to advance climate, energy transition towards fighting climate change. It's about enabling greater participation by marginalized groups. It is about national security, supply chain resilience. As one of our colleagues who also blesses us with his presence here, Nicholas Lamp, professor at the Queen's University in Kingston, has said, trade is increasingly multi-purpose. And so exceptions are one of the points that international trade lawyers can use in order to accommodate these non-economic purposes and these economic purposes in managing international trade relations. It's obviously also very important when it comes to international investment law. Just this week, we heard the news that an American company has sued Canada for $20 billion of damages for a failed project in the Saguenay region for the creation of an LNG pipeline. The project was ostensibly canceled for environmental reasons. And of course, that highlights how also the regime that is about international investment protection that traditionally has been focused on providing security to foreign investors is increasingly about trying to regulate foreign investment and trying to strike a balance between, on the one hand, attracting and protecting investment, and on the other hand, safeguarding other public policy objectives. And so investments are really at the core of much of the current debate in international economic law. And that's why today's talk is so topical. And we have really the best person in the world to talk about this. Professor Julian Arato is an expert in both international trade and investment law. So he can bridge this, these disciplinary silos. He has authored pieces in both fields. He has, let me just go to my notes here so that I don't forget any of his accomplishments that are many. So he has a JD from NYU in New York, a JSD from Columbia Law School. He has practiced law at Freshfields, and he is very accomplished when it comes to both academic leadership. He has been occupying leading roles at the American Journal of International Law, at the American Society of International Law. He's been one of the delegates to the UNCITRAL III investment law, investment arbitration reform process that is currently taking place. And he has award-winning publications. If you haven't come across any of his scholarship, which I doubt, but if you do want to read one piece, it's perhaps his award-winning Agile private law critique of international investment law, which won the Francis Deakin Prize. Without further ado, let me pass the microphone to Julian to learn more about the institutions of exceptions.
Yeah, turn it off for a second.
Yeah.
Is the volume all right for, it seems a little loud. Is the volume all right for Zoom, hopefully? Let's see if I can. Yes. Okay, those might be old yeses. I'm going to assume that they're new yeses. Great. Could I have just think you stole my notes.
Oh, sorry.
Need those. It's a good magic trick. So thank you so much, Wolfgang, for such a kind introduction and for having me here. It's a great honor to deliver the Hyman Soloway lecture and for such a kind introduction from the Hyman Soloway chair. I don't know if I'm the best person in the world to speak to this issue. I'm looking at several of the best people in the world to speak to these issues, but I will give you my take and hopefully it will be an interesting and atypical one. So the title of the paper is The Institutions of Exceptions, Embedding Policy Space in International Economic Law. International economic law is really a complex of multiple fields, where a common thread is that these regimes are about, in some way, integrating markets. States agree to treaty-based disciplines in the interest of liberalizing national markets, or in a sense, globalizing the marketplace. Now, most prominently, they do this with respect to the movement of goods and services, what's known as trade proper, the free liberalization of trade in goods, trade in services, that's what I'll be calling the trade regime, and with respect to the movement of capital, in other words, investment. Now, there are also economic disciplines when it comes to intellectual property and to international tax. I'm not really going to focus on them now. I'm focusing on the trade and investment regimes as the most prominent regimes in international economic law, but also the most institutionalized and the most heavily judicialized, which is really important to why they're scope limited for the purposes of this talk. One thing I want to mention right at the outset, though, for every student in the room who might not be familiar with either the trade or investment regime, is that there is not a single regime of trade, and there's not a single regime of investment. Trade, at least, is rather centralized through the long history of the GATT, the General Agreement on Tariffs and Trade since 1947, as further institutionalized in the World Trade Organization in 1994. So the World WTO really centralizes the regime, but there are many, many, many regional trade agreements and narrower side agreements of all sorts. A lot of them do link into the WTO system in various ways, but it is not a fully centralized system. Investment is completely disaggregated. It's really a complex of thousands of different treaties, many of them, most of them bilateral, some of them trilateral, like the NAFTA or USMCA or whatever we're going to call it. And there's some broader ones. But for the most part, it's disaggregated, disparate bilateral treaties that we can only speak of a regime because of the way that they have been judicialized. There's a lot of commonalities between these treaties. They're not completely common. There are important differences in the terms, especially in generations of the treaties. But from a 30,000-foot view, there's a lot of similarities, and they get interpreted in much the same way as Professor Alschner's work has wonderfully shown. So I'm going to now just speak about the trade regime and the investment regime, but we all know that these are not single treaties. These are complexes of regimes. Okay, so the goals of the trade and investment regime are mainly to incentivize cross-border economic action, trade, foreign direct investment, et cetera. And they serve as credible commitments at the international level. At least on some level, these instruments are designed to incentivize private economic action, commercial actors trading across borders, private actors investing across borders, investing abroad. The central tension, or a central tension that I'll focus on here, is in all of these regimes is how far these disciplines restrict the state's regulatory autonomy. In other words, how much policy space they leave to governments when complying with the economic disciplines in the treaties. Do states remain free to regulate in the public interest as they see fit, as they wish, or do the market disciplines come first? In other words, what gets sacrificed when the disciplines and the policy goals inevitably conflict? There is a strong public perception, very, very public perception, that regimes like the WTO and investment treaties with especially investor-state dispute settlement, that they get the balance wrong, that they tend to sacrifice all other values at the altar of the marketplace. It turns out that this perception is really not quite right, at least not in all contexts, but it does have to be said that in some specific cases, this has turned out to be spectacularly right and highly salient. So it's not quite right, but there's a reason for that public perception. But everyone would agree that the core tension to be managed in international economic law involves the balance between economic discipline on the one hand and the sovereign's reserved regulatory authority on the other. between liberalization and policy space. So the reality, at least as I see it, is that the trade regime has handled this tension rather well, while the investment regime has not. The substantive standards of investment treaties have been interpreted in ways that seem at least to highly prioritize market discipline over regulatory autonomy, and at the very least, in highly unpredictable ways, unpredictable both for state regulators, but also for investors. So what accounts for the reason in the trade regime? The key to the balance in the trade regime, especially in the WTO context, has been the general exceptions clause at Article 20, famously in the GATT, but also recreated in some of the other treaties like the General Agreement on Trade and Services, the GATTs, Article 14, doesn't matter. I'm just going to call it Article 20. When it's alleged that you, a state, have violated a market discipline, you may justify your action by appeal to a clause, Article 20, with several enumerated exceptions for legitimate regulatory goals. There's an environmental exception, a health exception, a public order, or public morals, depending on the treaty. If you are able to establish a justification, which involves very rigorous means-ends testing, you establish a legitimate aim, you establish that your measure was the least restrictive means available to achieve that aim, then there has been no breach. The putative breach has been expiated by your invocation of the exceptions clause and your satisfaction of its means-ends testing. So I'm going to call this type of exception really an exceptions paradigm of justification. It's not any old exception. There are other exceptions that are just carve-outs. This treaty doesn't apply to tax measures. That doesn't involve justification. But the Article 20 style of exception is about a justificatory process that takes place at the adjudicative phase. Yet where states have tried to, aware of the success of this system in the trade regime, where states have tried to implement it in the investment treaty context, the experiment really hasn't worked out. And I don't need to tell you this here in Canada, where Canada is really one of the early proponents of the Article 20 style clause in the investment treaties, and has recently dropped it from the model treaty, presumably not negotiating those clauses in treaties going forward, although there are people in the room who would know that much better than I. As Professor Alshner has said, the history of the exceptions clause in the investment context is really one of confusion, of failure to apply the clause. So the clause has been confused, has been ignored, and has most recently been utterly misconstrued. So this project is about reflecting on why that is. And in my view, this isn't really about arbitrators just getting it wrong. It's not doctrinal failure by arbitrators. It's not just about drafting problems. If only that this had been drafted in a slightly different way, everything would have been fine. Just tinker with the text, right? And it's also not a story about scurrilous or biased arbitrators. The issue is not just that arbitrators have their own agenda, in my view, and they're going to do whatever they're going to do, and it doesn't matter what you put in the exceptions clause. Whether or not any of those things is true, my argument is that the institutions of these different regimes are key to understanding why justification via exceptions has been so successful in the context of the WTO and has been doomed to fail in the investment context. The WTO GATT exceptions clause can't be understood in a vacuum. It's embedded in a wider institutional context, one where the structures turn out to be key to its success. So in this talk, I'm going to focus on three such institutional nodes. First, the nature of the right of action, which in investment is a private right of action versus a public right of action in trade. Second, the degree of judicial centralization of these systems, one-off arbitration versus a really integrated, centralized, multi-tier court system in the WTO, even if we're not allowed to call it a court. And third, the remedial structure of these regimes. A retrospective damages regime in the context of investment versus something closer to a structured injunctive relief system in the trade context. Prospective remedies oriented primarily towards, injunctive relief and getting the state to get into compliance. The argument, in other words, is that the institutions of the WTO have made the exceptions clause what it is and not the other way around. And there's no reason to expect merely inserting such clauses into investment treaties to have similar effects under the institutional constellation there. So in what follows, I'll set out the exceptions paradigm in trade and investment, develop the institutional account that I'm advancing here, and point finally briefly to some takeaways with regard to the trade and investment regime and the reform agenda in both systems. Okay, so let me set out the exceptions paradigm in trade and investment. And I'm going to talk a little bit about how these regimes work, especially for those in the room who may be less familiar, before getting to how the exceptions in particular work. So trade is about liberalizing commerce in goods and services. States agree to limits on border measures, tariffs, quotas, and to constraints on internal measures, such as regulation or taxation, insofar as those measures might affect trade, doing of business across borders. So the disciplines on tax and regulation are most prominently focused on non-discrimination. Thou shalt not use your regulation so as to protect your local producers against foreigners. That's the national treatment obligation. There are others, but just keep that one in mind for the moment. So let me do this with a hypothetical. Let's say that you, a trader, think that a foreign state is discriminating against you. You're an American beer company, everyone's favorite beer company. You're Budweiser. You get to be Budweiser. It's the best beer in the world. I'm joking. I don't think that. That's horrible. So let's say you're importing beer to Australia, and Australia passes a regulation saying no preservatives in beer. You're not allowed to use preservatives in your beer anymore. This gives a huge advantage to local producers. You kind of need preservatives to ship your beer all the way to Australia, right? So suddenly all of the local beer companies are going to be at a gigantic advantage over Budweiser, who produces the beer in the US. Now, you can't sue Australia at the WTO. You don't have a right of action. You have to petition your state, the US government here, to bring a claim on your behalf. Now, let's say they go for it. The US sues Australia for discrimination against its traders. You have a trial, there's an appeal as of right for both parties. If the US wins, it can get an order that Australia has to alter the regulation and allow your beer in. Okay, investment treaties work completely differently. Investment treaties are about foreign direct investment, where you, the foreign investor, set up an investment in another country. And investment law gives you certain protections, for example, against expropriation without compensation, or for fair and equitable treatment, which for our purposes, just think of as a non-arbitrariness obligation. It's much more than that, but just to simplify. And there's also a non-discrimination component. So let's do a hypothetical for that one. Let's say you, Budweiser, actually set up a beer factory in Australia because let's say this no preservatives rule stands and you need to set up a beer factory there if you want to be selling beer there at all. So you set up a beer factory, just to put a number on it, let's say you spend $1 million getting set up near Sydney, and finally, when you're about to start producing beer, Australia shuts you down. The government says you were polluting or you were mistreating workers or something, right? Whatever it is, we're removing your permits to operate until you fix it. So you can't produce beer unless you take very, very costly measures. You're out of business. Here, you, Bud, gets to sue Australia directly. You get to compel them into a one-off arbitration, international arbitration, ISDS, seeking money damages to be assessed at the present value of the enterprise that was destroyed, if you can establish that your enterprise was destroyed. If you win a judgment, you can enforce against the state anywhere in the world. It's not that easy, but for international law, it's a lot easier than a lot of other things. And there's no appeal. There is an annulment system, but it's very complicated and it kind of is hard to establish. I don't want to get into annulment right now. Now, what happens when the market disciplines conflict with the state's regulatory authority? Say the state claims its internal measure was for a valid public purpose. The preservatives rule is about public health. We drink a ton of beer here in Australia. Preservatives, if you drink enough beer, might be harmful, precautionary principle. Or the permit denial was about labor rights. It's because you, the Americans, are not treating our workers well, whatever it is. Okay, so the question becomes how we draw the line and how that line is policed and scrutinized. Neither system is a strict liability system. Everyone kind of agrees about that. It would be kind of unfathomable to imagine that states erect economic disciplines for which there is no escape hatch for public policy. So you're Australia. Let's take the trade case. The USA sues you for your local preservatives rule, and you say this is about public health. You get a chance to justify under Article 20 of the GATT. You have to establish first that you were pursuing a legitimate aim. That's pretty easy to do. Right, you would say that this is about public health here, about safety, something like that. Then you have to establish that your measure was necessary to secure that aim at your chosen level of risk. This, by contrast, is no joke. This is a really rigorous means ends testing. And you have to, while you are free to choose the level of risk that you're willing to tolerate, you have to establish that this was the least restrictive means available, a hard task, because what the claimant will do is establish all sorts of alternatives that you could have pursued, and you have to show why they wouldn't have worked to achieve the level of risk you were willing to tolerate. That's hard to do. It's a rigorous test. And then after that, you still have to show that the measure is not being applied in an arbitrary or unjustified discriminatory way as applied, or that it's not merely a disguised restriction on international trade. So these are a lot of tests. Okay, the case law in Article 20 on exceptions is really well systematized, and it's become a key feature of appellate body jurisprudence. It's not perfect. There's some slippage here and there. Happy to talk more about it, but it works pretty well, at least while there was an appellate body. The balance is this. Typically, tribunals are very deferential on aims. Tribunals, the panels, the appellate body have been very deferential on aims, but very, very scrutinizing when it comes to means. Okay. On the whole, the WTO appellate body can be said, I think, fairly to have a spirit of deference to state policy goals, rigorously permitting pluralism, in the words of Rob House and Joanna Langell, among national orders. This is not no scrutiny, it's rather rigorous scrutiny, but there's a pretty serious escape hatch for public policy goals. And the WTO appellate body has set the tone for the entire trade regime. In investment, it's much less clear how this all works. Many treaties don't say, everybody understands that these treaties are not strict liability, but some kind of justification has to happen somewhere, and it's just usually not that clear where it happens. Does it happen in the primary rules to establish a breach of fair and equitable treatment? Do you have to show some sort of bad aims there? Or is there a sort of chance at doing justification later? There aren't generally exceptions clauses in these treaties, so it's a little bit unclear where justification happens, but everybody accepts that there's at least some mechanism importing ideas of police powers or something. Some states tried to remedy this through formally inserting exceptions clauses in the treaties, sometimes modeled very explicitly on the WTO. And Canada is probably the most prominent example of a state that was pushing the exceptions paradigm as a way to resolve this problem. So this experiment, in my view, it's really laudable, right? The idea was this struck a pretty reasonable balance in the GATT context. So maybe this would be a way to do so here. But while it was laudable, it's largely failed, and I would suggest doomed to fail. Tribunals regularly ignore exceptions clauses. That's not entirely their fault because litigants regularly fail to bring them up. So that one has to be put, the blame has to be put where it belongs. But most recently, tribunals have occasionally really one tribunal has spectacularly misapplied an exception in a kind of critical case. But here's how it would work. Assume there's such a clause in the Australia-US treaty. Right? So Budweiser brings its FET claim, and Australia says, well, we were just imposing a bona fide workers' rights measure. That's all we were doing, and so there should be no violation here. Budweiser says, oh, well, of course, Australia is free to regulate in the interest of its workers, but this measure was too extreme. In fact, we think it was a pretext. And even if it wasn't a pretext, it was way too extreme to shut down our plant. They should have just demanded that we recognize unions or something pro-worker or whatever it is. They didn't need to shut us down. Now, Australia needs to defend its measure as necessary. They need to show that no, Budweiser's methods, their alternatives that they proposed, wouldn't have achieved the same level of risk tolerance that we were comfortable with. If they can do that, then they win, and Budweiser gets nothing, no money. If they can't do that, it would seem that Budweiser gets everything. It's all or nothing in this context, because this is a damages regime. Right? So even if Australia's goals were legitimate, were found to be legitimate, if the measure it chose was not the least restrictive means available on a rather rigorous means ends testing, they are completely on the hook to compensate the investor, just because they chose the not quite least restrictive means. So understand, this is an extremely high stakes decision for a tribunal. Parsing whether a government's measure was truly the least restrictive means becomes an all or nothing proposition, on which turns a sizable wealth transfer from a sovereign state to a private actor. Okay, one last thing I want to note is that one shouldn't think this whole debate and this whole issue is limited to investment treaties that have the exceptions clause in them. there are tribunals that have subtly moved into the sort of posture of justification via exceptions, even though there was no exceptions clause. So this is really spectacular in the Continental Casualty case, where the tribunal headed by Sacerdoti, who is a WTO appellate body member, said that, well, the test for figuring out whether a violation has happened here is the least restrictive means test. You know, go with what you know kind of thing. But there's more subtle ways in which some of the cases have kind of gone into this posture as well, something I'm happy to talk about more. But in the interest of time, let's just take it on faith that you don't have to have an exceptions clause to have exception style reasoning. It's kind of crept its way into the regime informally as well as formally. And it's just as problematic either way in investment. So hopefully it's already becoming clear that the particular modalities of the WTO's exceptions approach do not fit well in the investment treaty jurisprudence. With compensation at issue, the stakes of justification are wildly high. The equity is extremely difficult to manage without resorting to Solomonic baby splitting, and highly unpredictable. The results become highly unpredictable, the exact opposite of what this regime is supposed to do, make things more predictable for foreigners who wish to consider setting up a business across borders. Okay. Two things happened in 2021 that give occasion to confront all of this. And honestly, these two things are what made me start thinking seriously about this issue and its importance. The sound is not. Uh-oh, sounds like it. Oh, just getting to the. I don't know if there's too much I can do, but they don't have to hear this part right here. So we can hope. We can hope. The trials and tribulations of Zoom. Maybe let's just see if it's working for a second. Can you guys hear me now? No. Okay, good. Magic. Two things happened in 2021, of which most people in this room, anyone in this room, will be very familiar. The first is that Canada abandons the exceptions clause in its new model investment treaty. This is a highly significant moment because Canada was a major user of the system with both defensive and offensive interests, and has been the major proponent of the exceptions clause, or at least one of them, throughout the short history of this exception. The second thing that happens in 2021 is that the case Echo Oro versus Colombia is released. And this is a case that completely bungles the exceptions clause. It's the first one that really does it. Most of the time, it's a story of the clause being ignored. Most of the time, it's a story of the litigants not bringing it up. But at least in my view, this is a case that bungles the clause. And just to explain it very quickly, the facts of this is Colombia goes back and forth with the company for years about permitting mining in the cloud forest areas and arguably stringing the company Echo Oro along. It is not at all clear who should have won this case, right? As a matter of whether the investor was right or the state was right. Eventually, Colombia pulls the plug on the project, refuses a final permit on apparently real conservationist grounds. The treaty has a GATT Article 20 style exceptions clause in it. It's a Canada-Colombia treaty. And both Canada and Colombia argue that if the exceptions apply, then that should be the end of the case, right? The tribunal shrugs off any means ends testing. They don't actually apply the exceptions clause the way that you would normally accept. They simply say, well, even if the exceptions clause applies, the measure should still be compensable, right? Compensation should still be available. And the reason I say this bungles the clause is in a regime that is based on compensation only, the remedy is compensation. What does an exceptions clause accept you from, right? I mean, the whole point is compensation, and suddenly, well, you might have a valid exception, but it's still compensable, does nothing. It guts the clause. Okay. This case has been dragged through the mud, and I think rightly, but not always for all the right reasons. It has to be really clear that this is a case with really hard facts. Hard facts can make bad law. This is not a slam dunk environmental case where the state is being done some great injustice. There was real arguments on both sides, but the reasoning about the exceptions clause is bad. That's all I want to make clear for the moment. So if one focuses on Echo Oro, one might read all of this as, and I'm sorry, one more thing I want to say about Echo Oro because it's so famous and everybody is all up in arms about it. We don't have a damages award yet, right? So it could be that the tribunal comes out and says, well, yeah, exceptions are compensable, but we are only going to give you your reliance interest here. That wouldn't be a crazy result. It would be still terrible reasoning, but it wouldn't be a crazy result. Or to say simply, no damages, who knows? I'd be kind of shocked if they gave them full compensation, but I don't, who knows? I can't predict. I'm not Nostradamus. If one focuses on echo oro alone, one might conclude that all of this is evidence of tribunals run amok again, or the need to draft better, or another case, and I do believe there are many cases of new treaties, old interpretations. But to me, echo oro is more of a red herring. To me, Canada's abandonment of the exceptions clause is the more telling of these two moments. Canada, I think, is absolutely right. It's funny to tell you guys this, but I think you guys were absolutely right to abandon the exceptions clause, and that it's time to end this experiment, this particular experiment in the context of international investment law. It's not that the echo oro tribunal got it wrong. They did. The real issue, though, is that the institutional system here set that tribunal up to fail. And so I'm going to turn to why. To my mind, focusing on institutions helps to explain why the exceptions paradigm of justification has been so successful in trade, but really can't work well in international investment law. I shouldn't say can't work well. We should not expect it to work well or neatly or cleanly. And again, I'm going to focus on three different institutional nodes: the right of action, judicial centralization, and the remedial system. So what about the right of action? Why focus on this? Trade, again, has only a public right of action. Only a state can sue another state on behalf of frustrated traders. Whereas in investment, private actors can directly sue the state. There's two really important consequences of this. The first is, think of the different incentives in what claims the actors are going to make here. States in all of these regimes have both defensive and offensive interests. Not only do they wish to promote the interests of their outbound traders and investors, they also know that their turn in the barrel is right around the corner. They can get sued at any time. And that disciplines what kinds of arguments you're going to make when it comes to something like the exceptions clause. You don't see states in the context of the WTO often making the most aggressive arguments, trying to utterly dismantle Article 20 because they need Article 20 themselves. But investors are completely different. When the investor is bringing a claim, even repeat players, when they bring the claim, these are serious cases. I mean, they're not really often frivolous cases. It's very expensive to bring a claim. And you bring a claim because it's typically like a bet the company case or a major loss potential if you don't sue. You're destroying your reputation with the state. You're risking your reputation with others. These are really about getting what you can. And investors have every incentive to minimize any kind of public policy exception in a treaty, because all that those do is prevent them from recouping. So the incentives are completely different. States have a glass houses dynamic. They're not going to bring any and all claims, while investors simply don't. The other issue here is that there's really different political economies in these two systems. Think of what happens when a tribunal is faced with a claim by an investor. The investor comes to the tribunal harmed, right? I'm just talking about the psychology of it. Investor comes to the tribunal harmed and says the state, sure, maybe the state is trying to regulate, but they're trying to dump the costs of their regulation on me, a foreigner. There's something wrong about that, right? That's the argument that they're going to make. And, that's not completely wrong. So why? Promises were made. Echo Oro is a case where promises were made. They brought me here. They've been working with me. They kept promising, I'm going to have this investment. I just have to comply with this, comply with that, do this, do that. And eventually they pull the plug. Okay, maybe their goals were noble, but why should I bear the cost? Those types of rhetorical strategies have an effect. Right? I'm not saying it's right or wrong. I'm just saying understand the difference between a state bringing a claim on behalf of some disaggregated group of traders versus an investor coming, hat in hand. Poor me. It's like Oliver Twist, except it's ExxonMobil. Second, centralization of the system. Why does that matter? There's some obvious aspects into why this matters, but some less obvious ones as well. So trade, again, is a hierarchical, systematized, precedential system of adjudication. Within the WTO, at least, but remember, the regional trade agreements very often key into that system as well. There's often obligations, like in the CPTPP, to follow WTO appellate body precedents. So it's rather systematized, at least until 2020, when the appellate body cease to exist, thanks to my country. Sorry about that, guys. Not my fault. We'll talk more about that in a minute. But it's the WTO appellate body that has made the exceptions paradigm work. It's made it what it is, and it's policed its bounds. We can already see a little bit of slippage in some of the arbitrations, appeals by arbitration that have emerged after the appellate body has been in the icebox, where the sort of typical jurisprudence on how Article 20 works is showing some fissures. That's a conversation for another day. But we shouldn't necessarily expect all of these gains to last forever. It's the institutional structure of an appellate body at the top of this, at the pinnacle, that has managed this exceptions jurisprudence so prudently. In investment, there's no systematicity. So even if one tribunal were to get it right, let's say Echo Oro got it right. They said, you know what, we understand the exceptions clause works exactly like it does in the WTO. We'll do a least restrictive means analysis. Colombia here did not use the least restrictive means available to it after it engaged in all of this sort of rope-a-dope with the investor, and so they lose. I don't think, well, some people might still be up in arms. I certainly wouldn't be up in arms about that case if that was how it went down. But if they did it right, there's no reason the next tribunal will get it right, or the one after that, or the one after that. One can hope, but hope is an expensive commodity. Okay, so there's no systematicity, no precedent, no predictability. These are very common points in talking about the ISDS system. But what I want to stress is even more than those, there's no management, there's no responsiveness. The magic of the WTO appellate body in its exceptions jurisprudence is that it's been able to manage this process and be responsive to reactions by states over the long term. It has had a sort of stewardship role over this system. And that's something that's simply not possible in the investment context. So it's not just predictability, it's not just precedent, it's actually a managerial form of adjudication that is necessary to making this form of justification work. Finally, the remedial system, the third point. Trade, again, has a sort of structured injunction system. You have to end your measure now, and if you don't, we're going to be willing to order temporary compensation, prospective compensation, until you get into line, right? Investment, by contrast, is retroactive monetary damages, all or nothing, and the stakes are really, really high. So this helps explain, I think, the tribunal's instincts in a case like Echo Oro to make the exceptions clause compensable. You just look at this, the investor's coming to you, they have been strung along, there is this exception, but the investor is saying, why should we bear the cost of Colombia's laudable environmental measures? And, you know, it's kind of a good question, right? So I can understand the instinct to make the clause compensable, even if I think the reasoning is completely wrong. So maybe, I think it also is worth bringing in that tribunals have relatively recently been shifting to mitigate some of the earlier, I think, more abusive aspects of the system in the context of damages. Damages awards, not all of them have gone down, but there's been much more flexibility introduced into the system with damages. It's not altogether a bad thing, but it's not really, you can't run a ship like that. At the end of the day, that's not a particularly predictable system for everybody involved. Okay, so the conclusion here is that, in my view, the public-oriented institutions of the trade regime set a fertile ground for managing the balance between liberalization and policy space with exceptions-based justification. But the private-oriented institutions of investment are very poorly set up for this to work. I've got some lessons, but I feel I've been going on for a long time. We end at 6:30?
We end at 6:45.
6:45.
If you want 5 minutes. 5 minutes,
perfect. I'm going to give the speedball lessons. Okay, lesson number one. On current institutional models, I think part of the lesson here is that the exception solution needs to be put to bed in this system. It makes total sense that Canada has dropped the clause from its treaties, but that's not it. Again, tribunals are fairly regularly introducing some version of this kind of reasoning, whether it's through literally doing least restrictive means testing, that happened only once to my knowledge in the Sacerdotes Continental Casualty case, or through more subtle versions of it through standards of review like the margin of appreciation, things like that that get you into much the same place. I think that experiment has failed. Deeper than just the clause, the reason to be suspicious of managing the policy space problem through ex post adjudication, adjudicative justification, there's reason to be really suspicious of that going forward in all of its forms. Lesson 1.5, this is not an argument on its own for an investment court. I'm not saying an investment court would be bad, it could be very good, but saying the exceptions clause doesn't work in this system of institutions doesn't necessarily mean the solution is to replace it with new institutions. That might be good for its own purposes, but there are also other ways of addressing this particular problem. So I don't want to make the point that this is sort of just another argument for the court system, even if a court system might be able to deal with some of this problem. But I will just say that a court system on its own wouldn't completely resolve the issues that I've been talking about, because the remedial system is still quite different, and the private right of action also creates different kind of incentive structures for which this mode of justification is not amenable. Again, not an argument against the court, not really an argument for the court. Second lesson. This comparison, by contrast, I think makes a pretty substantial argument in the trade context that we need to be careful to preserve what we have. Right? So in a sense, this is an argument for stopping the bleeding in the trade system and bringing back the appellate body if that's at all possible. I don't think the people who need to hear this argument are in the room or are ever going to listen to me about it, but nevertheless, it is an argument that the appellate body has been a really critical part of the foundations of the trade regime and why this regime has struck such an effective balance between policy space and liberalization. One can hope, again, that it comes back, and I think this is an argument that we should consider preserving what we have. Finally, a lesson for international economic law generally about legislative and judicial borrowing. The lesson is that it's really critical to look to institutions first before looking for one neat trick that might work in one system and we just lift it into this system and it will work here. This type of borrowing is all over the place in international investment law. It's usually not on the legislative side. It's usually, well, everyone works from models on the legislative treaty-making side, but you really see it in the adjudicative side, where arbitrators searching for a standard of review to apply, pluck one from here, pluck one from there at the suggestion of the litigants who bring them up. And one understands it, right? You have to do something. The investment treaties are really short. They don't tell you anything about the standard of review 95% of the time. So one has to do something. But I think the lesson here is that just because something works well in one system doesn't mean it's going to be easily transposable to another. We should by all means borrow judicially, legislatively as a source of inspiration, as a sort of experimentation across treaties, across cases, across national law at all. But the lesson is that we must not become slaves to the convenience of arguing by analogy. So that's all I have, but I look forward to your questions, critiques, comments, but just to say thank you again for inviting me here, and it's been a great pleasure to talk to you all.
Oh, thank you. So thank you very much for this terrific lecture. I want to avoid passing the microphone back and forth.
Sure.
So what I would suggest is that we take questions from the floor and you just rephrase the questions for the Zoom audience, and I will get some water for you. So why don't you get started, and I'll monitor the chat afterwards.
Okay.
And if you could say, they get also questions online.
Yeah. Yeah, I can try to monitor the chat. Probably won't. All right. So yes, if you have questions online, just write them into the chat, and they will get fed into the hopper later. Yeah, Nicholas.
One comment, one question. First, on whether states are really less aggressive in their arguments, I wonder. I saw states making pretty destructive arguments. Like in youth pool, I mean, Canada with asbestos, ECC products. So maybe the law firms who defend states, they just also want to win at all costs. So I wonder whether you overstated it there. But my more fundamental question is there a fourth? What about the underlying structure of the obligations? Is that maybe a fourth factor, like the fact that you have reciprocal obligations in the trade regime, whereas there's asymmetry in obligations between investors and the host state, where the investor essentially doesn't assume obligations. So you have this idea of this bargain, this balanced bargain in the trade regime, and then you have something quite different in investment. So I don't know whether the underlying structure of, you get into that with the remedial structure, but yeah. I wonder whether the underlying obligation plays a role as well.
Yeah, thank you for both of these. On the first, are states really less aggressive with their arguments? the last refuge of scoundrels here is to say, well, the incentives are quite different, and that's already important, right? I mean, do we know what the traders themselves would have argued in trade case after trade case after trade case? We don't know the counterfactual. My suspicion is that it could have been worse. But the real point is that this is what I really should phrase this as. This is about the incentive structures set up by the different nature of the private right of action, which is not to say that states won't do something incredibly aggressive in a particular case. There's, for example, reasons why they might not think about their long-term defensive interest because of immense political pressure in a case in front of them, right? Maybe that was what was going on with asbestos, for example. I wasn't there. But this is just to say that in investment, it's always like that. The incentive is always to smash and grab and do as much as you can. And this is not an attack on investors. That's exactly what they should be doing, right? If I was advising an investor in an investment case, I would not say, well, we must preserve the sanctity of Article 20 style clauses. And that's what's been copy pasted into this treaty. So, hands off that, but otherwise I'll try to get you a compensation. Whereas in trade, the law firms might not have the same incentives, but you would imagine that it's at least a pretty important consideration, right? There could be other countervailing considerations, or one could simply forget, hopefully not. But so that's just to say, I think there's a huge difference, but you're right to say it would be overstating the case to say that states never make aggressive arguments in the trade and that everything is nice and everyone is friends. I do not think that that is the case. The second point, I think you're absolutely right that there's potentially a fourth one there, but I don't know exactly what to do with it. So the idea, I didn't restate the question. Sorry. The second question, I'm just going to do it for the second one. What about the underlying structure of the obligations themselves? Is that a fourth different institutional difference between the two? And who cares whether it's institutional or the primary rule? I don't really care about that. Is that a force critical difference? So I've been thinking about that a lot, actually, and not exactly in the same way as you suggested. So one possibility is that their obligations that are involved are obligations that are addressed to a state. They're aggregate obligations in the context of trade. There are beneficiaries. The point of these obligations to the reciprocal obligations between states is to incentivize private action, at least on some level, but you're not really giving a right to a private actor by any stretch of the imagination, not a procedural one, not a substantive one. In investment, there's an argument that a substantive right is being given to an investor. And there's a whole debate about whether these are truly rights or whether they're third-party beneficiaries. Honestly, I don't care. I don't really think that that matters that much. I think it's a little bit of legal semantics, but I could be convinced otherwise. The point is the investor has something here. And does that make a difference? I'm not sure what difference it would make as separated from the differences that are captured by the right of action. But I do acknowledge that it's something quite different. The way I try to capture it is the psychological effect of saying my right has been violated. I guess what one could say is that it speaks to a different purpose of these regimes, right? One in which compensation and the compensation prerogative in the investment context makes a lot more sense, and we should be a lot less. We should expect less that a tribunal will readily drop that purpose in that context where private rights are involved. But I'm really not sure. I need to think more about that. I do completely agree with you that it's a difference between the regimes. I'm just not sure what purchase it really has in this particular case.
Take one.
Sure.
Slides or judge questions here. Just go through them and do one of those.
Oh boy. My answer to the first one is going to be disappointing. Canada added a new exception clause to its model FIPPA, which I take it is the acronym for the model bit. Okay, it's model FIPPA for Indigenous rights, modeled after USMCA Article 32.5. Any comments on this development? No is my answer, but only because I'm not sufficiently familiar with the phrasing. However, and maybe someone in the audience can confirm for me, my understanding, my guess is that this isn't the kind of exception which involves justification, like Article 20 style justification. It's more of a carve out. But is that, yes, I don't know. I don't want to answer this without knowing more. But I'll take this opportunity to say something extremely general that is not about Indigenous rights, which is to say there are different kinds of exceptions out there. right? One kind of exception says you are off the hook if you can state reasons, show a legitimate reason, show that this was the least restrictive means available to pursue that reason. That's the sort of justification via exceptions. But there's another type of exception that you see pretty frequently, which is more in the nature of a carve-out, which is to say, for example, this treaty doesn't apply to tax measures, or more apropos, this treaty doesn't apply to climate measures, something like that, or this treaty doesn't apply to tobacco, right? And one can debate whether or not those types of measures are the right way to handle the flexibilities, and there's something sort of odd about doing it one by one, carve out by carve out by carve out. But I do think that they don't suffer from the same problems as exceptions with based on justification. So one thing that I would at least suggest is where something is really, really, really important to a government to keep out of the treaty, the carve out might be the better tool. But too many carve-outs, too broad a carve-out, that's going to have its own problems, and we shouldn't delude ourselves into thinking that a tribunal is going to give states a free pass ever. There's always going to be some kind of review. There's not really that much you can do to get out of that unless you stop having dispute resolution, at least in my view. It wasn't really an answer to your question. I just took it as an opportunity to talk about something that I know about.
Some more questions?
Yeah. Yeah, Professor McCrae.
Thank you much. I'm not sure what I'm going to say is heading in the right direction, but one of the things about the question that you sort of put aside, because you said you're not going to talk about the arbitrators who are actually making decisions now. But there is a dimension.
Yeah.
Who is making the decision in trade cases? Who are arguing the cases in trade cases? Who are making the decisions in investment cases? You are arguing the cases. And I mean, put it in terms of government versus private investor. If you go back to the history of WTO, the initial appellate body, were to the extent that they had trade experience, pretty much steeped in the GATT, and therefore argued. The people arguing cases before the WTO were often in the early cases, which were largely a small group of countries, people who came from the GATT experience. And so therefore they had an understanding of this. What you do is you take the Article 20 exceptions like and put it into an investment. And you ask who's arguing. Well, the council will argue investment cases, put aside countries like Canada and the United States have their own in-house lawyers. The council argues a private level, largely with commercial arbitration value. And the large proportion of people deciding come off that background. So I think an expectation that we get that sort of institutional, the idea that governments are different from other litigants, that's a harder road to hoe in the investment area than it has been in the WTO area. So I think that might be a useful avenue to look at into why the exceptions have failed in one, where they seem to have been developed and working together.
Yeah, I think as an I think I actually can. So the Professor McCrae's point is that one also has to look. It's not exactly about the institutional structures, but about the who decides and who argues. And the point was that in the trade context, in the WTO context, those who were initially arguing the cases and those who were deciding it all came from a collective background steeped in the GATT, in the long experience of the trade regime since 1947 till 1994. They were trade people who were steeped in Article 20 of the GATT, because in 1994, the GATT was simply copy-pasted into the new system. Nothing changed. Whereas in investment, those who are deciding cases are people from, well, originally kind of commercial arbitration backgrounds, to use the old hat. I don't know if this is entirely exactly correct, and some with public international law backgrounds. I really don't want to go down this road too much, but they're certainly not trade lawyers, right? With a few exceptions. When you do get those exceptions, sometimes they start doing least restrictive means analysis. And more importantly, those who are arguing the cases have no trade background at all. Right. And so why should we have expected that these clauses would have the same sort of results? Clauses are not self-executing. They're not automatic fixes. So I want to say a couple of things about it. One thing I want to say about that is that, you sometimes see it out there in the literature that it's almost a knock on the approach of copy pasting the GATT Article 20 language into the investment regime. It's like, oh, a couple of words were changed. They just did a Control F and found trade and they replaced it with investment. I think that's a really unfair characterization. I think part of the reason of using the exact same language is to demonstrate that this is supposed to copy what worked in the trade regime. So this was actually an attempt to, not exactly incorporate by reference, but really, really obviously as you can get an investment treaty, signal something, right? I mean, I guess you could have a footnote that said this should use the same standard of review as the trade regime, but that would be a little bit gilding the lily, I think. That's about as far as you could go as an institutional design choice, short of mandating the arbitrators, maybe with lists or things like that, right? So Professor McRae's point is, why should we have expected that this, if the people who are involved in these regimes are so different, why should we have expected the result to be so similar? And I guess what I would say is, I think that that's probably absolutely right as an explanation of where we've gotten. You look at the cases which involve the exceptions clause, most of the time, the exceptions clause is just ignored. The litigants don't even bring it up. The state's litigants don't even bring it up. Or when they do bring up some kind of exception, they bring up the wrong one, or not even the most powerful one, right? This is a point that I learned from Professor Alshner's book. And it's kind of remarkable at first until you realize that, well, why would they? They don't have the experience in it. The GATT clause, I mean, you could look at the GATT Article 20 and think that's a pretty tough standard of review. Maybe I don't even want to use that. I don't want to bring that up. I want to bring up the sort of right to regulate, the sort of looser language there, because that seems like that might be more friendly, right? So there's all kinds of reasons why. But I think my answer to this, and to bring in Professor Alshner's book on New Treaties, Old Outcomes, is that I think what this does is undercut the story that we should expect that this, okay, I'm going to say it this way. Arguably, those are just the growing pains, right? Arguably, with enough time and enough cases, the early cases aren't going to get this right, but now we're starting to see in cases like Echo Oro, the non-disputing party submission by Canada saying, no, this should mean it's not compensable, right? And presumably over time, it becomes a little clearer how you're supposed to handle these clauses if the states are really committed to these exceptions clauses. So yes, I can understand why the early cases aren't going to go well, but you'd think maybe over time, if this was really the right way to handle this, you might have a different result. But my feeling is that the institutional setup prevents that from happening even in the long term, right? So I do think that this is an explanation of why this hasn't worked so far, but the explanation for why I think it can never really work is a different one. Still, a point well taken, and one that will go into the paper when I write it up. So thank you very much. Okay, from Ismailov.
We have one more short one. You can
Oh, from Anonymous. Thank you, Anonymous. Not the hackers, hopefully. So can joint interpretations by the home country and host country help address this question? Thanks. Thank you for that question. My answer to that is, I don't know, maybe. I'm not enthusiastic. The problem is that the joint interpretations, non-disputing party submissions, briefs, joint interpretations are all ways to signal to a tribunal how they should engage with an interpretive question, and the joint interpretations presumably should be pretty authoritative. States are the masters of the treaty. That should be the end of the story. That's it, right? But we have so much experience in this regime showing that tribunals don't see things that way. They think of themselves as authoritative interpreters as well, and if they want to go a different way, that they can. I think the joint interpretations can help answer Professor McRae's concern, right? If there's a lack of familiarity with how these types of clauses are supposed to work, you can flesh it out through a joint interpretation or a commentary or any kind of thing like that. But if it's a question of truly constraining a tribunal to do what you want them to do, I don't think it's going to cut it. I think much more important to focus on solutions in either the primary norms themselves or to think about solutions in the institutional structure. And what I tried to say inartfully earlier on is that I don't think this is necessarily an argument for institutional reform. I do think institutional reform is valuable and we should pursue it, not because of this. But substantive reform can solve some of these problems as well. For example, you can build justification into the primary norms themselves in ways that aren't as susceptible to some of these problems. In the WTO context, there was the old debate about whether or not non-discrimination involved an effects test or an aims and effects test. And aims were sort of not included as part of the test because we have Article 20. one can disagree with that, right? I have my own suspicions about that, but at the very least, there's a chance to justify and the stakes are lessened, right? In the context of investments, not just non-discrimination, arbitrariness, that necessarily involves aims, right? You can't, what kind of measure would be arbitrary if we didn't ask about the reasons? It's about the wrong reasons, right? Procedural or substantive arbitrariness. So I think you can build in justification on that end without necessarily having all of the problems that I mentioned. I could get more into that though, but I want to take more questions if there are. Yeah.
Maybe I could just pursue you a bit on that point, Julian. I'm not sure why you think it's likely that this compelling argument made about the problems with the institution of investment is likely to undercut fundamentally the success of any effort to create exceptions. But why would we get a different result if what you're doing is kind of tweaking the substantive standards? And a related question is, of course, the approach that the Canadian government has now taken in the PIPA, having abandoned the exceptions, is to incorporate a more direct expression of the right to regulate as a general proposition, and whether you think that will go any way towards shifting the balance given the kinds of benefits you described in
Okay, so on the first, my reaction was to the second. Yes, okay, so the first question, thank you, Professor Van Dusen. The first question was, well, if all of these institutional hurdles are in the way of an exceptions clause working to establish kind of a justificatory system where the state has the ability to show that there hasn't really been a violation because they have a good justification. If it doesn't work with exceptions, why should it work if we just build it into the primary rule? Question one. Question two is, what do I think about a sort of much more general principled statement of the right to regulate? How would that help in this situation? And that one is the one that I'm more scared of answering, but I will do my best. On the first one, so I want to resist the notion that there are any clean fixes in this system. And I'm certainly not saying, when you go on BBC or CNN.com, one neat trick to solve all of life's woes. It's not what we're going to get here, right? I do think that doing some of these things on the front end in the primary rule, however, can help avoid some of the problems that I've mentioned, not all of them. So it doesn't help you with the judicial centralization problem. But it, I think, does create a different political economy vis-a-vis the private right of action. Because now the investor, and it's not just about burden of proof, this is about the subtlety, the sort of cognitive effect. The investor has to come establish that they have been treated in a way, let's say it's arbitrariness, that I have been subjected to arbitrary action because the state has done something for bad reasons, right? And again, I'm not saying that this is something that the burden of proof has to be on the investor. I'm just saying the investor is going to say that the state is going to say what their reasons were. And this is all at the point of deciding whether even a prima facie breach has happened, which doesn't leave the state on the back foot. I think there's a subtle effect to saying, okay, you established a breach on effects only, right? Something bad happened to the investor. And now the state has a chance to sort of explain by way of exception its justification. I think there's a not so subtle way that puts states on the back foot in trying to accomplish the same kind of balance between discipline and policy space that was accomplished in trade, particularly because the stakes are so high. So it's the combination of the private right of action and the availability of damages that I think make the sting of doing this through exceptions much harder. I can't prove that, right? That's a conceptual point, and it's one that I think is intuitive, but I will certainly say that if an arbitral tribunal was interested like in coming to a certain kind of result, none of this is going to stop it, right? Maybe carve-outs can stop that, but again, this isn't an argument about the scurrilous arbitrators doing whatever they want. This is an argument assuming that everyone is trying to get the law right. Okay, on the right to regulate one. So I think there's benefits to that type of clause, but as a signaling device, and if it were the case that the sort of main substantive standards were clipped in significant ways, like let's imagine we took out FET, from these treaties, right? And you've just got ex pro, and there's maybe indirect expropriation, and then you have the right to regulate, crystal clear, right? I can imagine that having a discipline effect on tribunals in how they apply some of the substantive standards. But with the way that FET is now, it's harder for me to see. And I guess this is really kind of going towards Professor Alschner's argument that, the barnacles of jurisprudence that the system has all over it now, I just don't know if that clause is enough to walk all of that back, which speaks to the efforts at institutional reform, right? Now, something like the right to regulate as a principle, once you start to couple that with a much more serious effort at systematizing institutional reform, the investment court and appellate mechanism, those kinds of reforms, that starts to make more sense to me, right? Because you're talking about an institution that would be capable of, over the long haul, observing and managing what that right means, rather than just a tribunal on a one-off basis, having litigants saying to them, well, of course, that can't mean that the state's free to do whatever they want. And then what does it mean? Who really knows? There's no standard of review. There's no nothing. So let's just do what we've always done, right? So that's sort of how I see it going on current institutional models. But again, I'm not Nostradamus. I can't predict what tribunals are going to do. One could easily also just imagine that with enough sunlight on these issues, tribunals start to look for reasons to give investors less because we want to preserve the system. So, there's reasons why it could go either way. But I think that at bottom, those kinds of clauses make more sense with institutional reform as well, because they're too hard to expect one-off arbitral tribunals to manage them in a serious way. Yeah.
Yeah, since you're asking about institutional reform, I was wondering if you think there's any role for transparency and confidentiality rules that might come into play for arbitration rules that are.
So transparency and confidentiality rules. So I guess if I'm understanding the question, right? So the question was, do I see, as far as institutional reform goes, do I see there being any role for transparency and confidentiality rules? And by confidentiality rules, you just mean the opposite of transparency, or unless I'm misunderstanding? Yeah, okay. So the question of how transparent we make the system. Look, I think transparency is a good thing, right? And I think transparency is part of the reason why this system has a quasi-presidential status at all. Which for some, that's in the eye of the beholder. Maybe that's good, maybe that's bad, but I think sunlight on this regime is really important. So transparency, I'm all for it. I don't think it solves any of these particular problems because we've had transparency. You haven't had total transparency in this regime, but we've had more transparency in this regime than any other regime of arbitration out there, right? And with transparency has come, a lot of clarity about the inconsistencies in the awards, a lot of clarity for academics, for observers, for states about what's happening in different aspects of the field. But that transparency has not had a disciplining effect on arbitrators by any stretch of the imagination. I'm going to walk that back. I actually don't believe what I just said. It has not had a major systemic disciplining effect. I take it back though. I think, I'm selling your comment short. There are cases where the transparency has really mattered because we've known what was going on in the case while it was happening, right? And so I'm thinking of, I can't prove any of this, right? I'm just going to say a bunch of stuff. I'm thinking of the Philip Morris case, the cigarettes cases. The fact that it was so clear what was happening the whole time, I think had a really strong disciplining effect. I've written another work about how I think the investment treaties have distorted domestic private law arrangements insofar as they've been applied to contracts, property, IP. And it turned out that the cases which involve IP tend to come out right, as from a private law perspective, and the other ones don't. And that's because the IP cases are so salient, right? There's so many people looking out for that because of the experience with the TRIPS and the reputation of the TRIPS, which is, by the way, I think kind of unfairly earned, right? But so the moment the IP cases come out, Eli Lilly versus Canada, the Philip Morris cases, suddenly, the tribunals are handling these cases with a lot more delicacy. And so I think there can be a disciplining effect from transparency. I don't think, though, that it can be a systemic disciplining effect of the kind necessary to accomplish justification by exceptions. So thanks a lot for that question.
We have time maybe for one more short question from online. So if you just pick,
Maybe I take them together and I can answer them together.
In the room, the people will be able to.
Okay. Sorry, Anj.
Join us then for the research. But the,
Okay,
it's not like
okay.
the notes. So,
Fair enough.
uh,
Do I take the one at the top?
or at the bottom, or a short question that's
They're both long. Okay.
there's some further down the road.
Oh my God. Okay.
2-minute response.
I'm just going to read Lothar's because he's talking about it. Okay, something that I know about. If I'm not mistaken, you have in 2021 a publication with Kathleen Clausen and Ben Heath that expressed the view that it's wrong to rely on exceptions clauses like Article 20 in GATT cases of most obvious justification, but instead the basic obligations should be applied by departing from their text and reading into them a possibility of justification. Do you still hold that view? I'm going to read a different question. Thank you for that, Lothar, but I already answered it, which is yes, I do. And I'm happy to talk more about that. Just send me an email, but I do still hold that view as I was explaining earlier. Okay, Anne Hertigan. Thanks, interesting talk here. Lesson 1.5 is that you're not necessarily arguing for an investment court because the problems of the cause of action and the remedial structure would remain. And you also mentioned there are other ways to address this problem. Could you elaborate on which other ways you have in mind? I also just answered that. This is hard to do. Okay, one more. So will the potential trend of abandoning exception style clauses result in states putting in more carve-out clauses to curtail the material scope of application of future investment treaties and potentially force states to draft better and clearer substantive obligations going forward, or can't we necessarily see that correlation at least yet? I have no idea what it will prompt, but I guess I want to say one thing from my contracts background. I teach contracts and I think about contracts a lot. And one lesson from contracts, which will be very clear and obvious to those who have negotiated treaties in the room, but for others, complexity is not necessarily a good thing. There's an instinct that we can if we just answer everything, like what are the things that we're going to be concerned about? Let's just put them in the contract. Like I have a contract with some producers, coffee producers in Costa Rica. I have certain kinds of risks that I'm thinking might happen. So I put in a force majeure clause that lists hurricanes, that lists earthquakes, whatever it is. And the more you put in, the more covered you are. And there's a common refrain that investment treaties are so short that that's their problem. They're just these broad standards. How could states possibly have engaged in these really broad, short treaties? It makes no sense. We should just clarify everything. Turns out clarity doesn't necessarily help you in the long term. First of all, it's very likely that you're going to miss a lot of things that you should have put in there, right? Because we are not omniscient. And by missing things that you should have put in there, suddenly there's an implication that you really didn't care about them. So that's bad. And the second thing is that the more you put in there, the more a sophisticated counsel is going to have ammunition to destroy you with, right? The more you put into your contract, the more you put into your treaty, the more danger there is. So, it's really hard with this regime. Again, there are no silver bullets. There's no one neat trick, but complexity is not necessarily the friend that we tend to think that it is. And this is relevant to carve-outs because if you're going to start to try to manage stuff, these risks through simply carving things out of your treaty, you're going to have to put a lot of carve-outs in there or some really broad carve-outs. The broader they are, at a certain point, you don't have a regime anymore. So maybe we should just pack up and go home. Maybe we should, right? But if you're not going to do that, then you're going to have lots of really specific ones and run the risk that, well, if you didn't list it, I guess you didn't think it was important. Sorry, you didn't know about climate change yet. Boo-hoo, so sad. That's a horrible way to end this talk. But I think that is how I'm ending this talk. Climate change is bad.
Well, then let me join. Please join me in thanking Julian Arato for this wonderful talk. And there will be a reception upstairs. Please use that opportunity to ask all your questions. And let's clap first.
Thank you all so much. This has really been wonderful.
Maybe you take the... Just also want to thank the online for joining us, and I'm sorry that we couldn't get through all your wonderful questions. I'm sure that Professor Arato is willing to answer any outstanding questions also via email if we didn't get to them yet. Thank you again, and please watch out for our future events. Good night and goodbye.